Please join me in welcoming Mr. Jose Martin.
Good afternoon, everybody. Thanks for having me. Thank you, and hello, Wyoming friends. Wish I was there in person. I'm looking forward to my next trip to Wyoming, but I'm joining you virtually to go over an important topic of special ed, and that's the child find obligation. Before I get there, I want to tell you I am this week actually completing 30 years of special ed practice, and I started as a practicing attorney in special education because I happened to have been working at a law firm that did school law, and a lady attorney from that law firm started using me to do some research on special ed issues. And then when the firm lost another attorney that also did special education for this school law firm, I was just told to take over her cases, which was intimidating, to taking over those files. And in fact, right off the bat in '91, I litigated and won my first special ed hearing. Thankfully, you guys don't have a lot of that. That's a long time ago. You guys don't have a lot of hearings. I will talk about cases, not so much as some kind of an incentive for compliance, because you might get cases, because I know that Wyoming is a low litigation state, but I think cases can bring a lot of lessons when you see practices, bad practices and good practices you can learn from cases. So we'll get into cases a little later, but I will speak first as to exactly what child find is and where I want to go to the core. Where do those legal requirements come from in IDEA, and what do they mean by this obligation? And through the presentation, I'll provide some ideas and helpful practices with respect to child find, and I'm quite interested in your questions. So don't think of questions as interrupting me. I'd rather take your question than continue speaking. I think questions can add a lot of content. I know that in virtual presentations, it's been my experience that I get fewer questions, but you shouldn't get intimidated because you have to type out your question. Don't worry about that. So I want you all to be free with your questions. If I say something that doesn't sound right, that doesn't agree with what you've heard previously, or you don't understand something that I said, I'd rather that we clarify it with a question so you can help other attendees in that way. I'm gonna start with the content, and what's child find? Well, simply put, it's the duty to find students within a local education area agency's boundaries that may be disabled and in need of special education, okay? And this flows from a statutory provision. This requirement is so important under IDEA that it's included in the actual federal law, which I cite there. And obviously there is a significant federal regulation that helps implement the content of the federal law. That's how IDEA works. So you have a big, long law, but there's also dozens and dozens of regulations that help us understand and help implement the law. Sometimes the child find requirement is called identification, but I find that that can be a little misleading. When you're identifying a student for special education, you're actually not determining their special ed, okay? The identification and child find process is intended to catch students that might be eligible, okay? If you suspect that a child is disabled and in need of special education services, that's what triggers a child find duty. You won't know if they're actually eligible or not until obviously you complete the initial evaluation, and that is reviewed by an IEP team, and the student is found to meet criteria. Then the child becomes a special education student, obviously if the parents consent to placement in special education. So identifying a child for child find purposes really just means that you're identifying them for referral to special ed. I'm going over the requirements of the regulations. They clarify that the child find obligation is coextensive with the FAPE obligation in terms of students' ages. Now, what do we mean by that? That your child find duty starts running from third birthday all the way to 21 till the students age out. So potentially a child that's 18 years of age could be entitled to child find and could be referred at that time, and a 3-year-old could. Okay, so there's no time frame at which a school district can legitimately say, oh, the child is too young, as long as they're 3 years of age. And there's no time frame where you could say, well, the child's too old for identification as long as they're under 21. And that's significant to understand, because I have found, and you'll see some cases that reflect this, where there's some resistance or some reluctance to evaluate students really, really early on. And we'll talk about that. Further on the child find requirement, they tell you child find applies, meaning the duty to refer a child could apply even if the child is passing their classes. That's really important. So the child could actually be apparently progressing in the regular classroom and nevertheless qualify for a referral to special education. And later we'll see some cases where that kind of example is brought out. I think too often we think of special ed students as only those students who have an academic need for services. And that's not the only domain in which students are expected to function in the school setting. I mean, we expect students to function in the school setting, certainly academically, but we also expect them to function behaviorally. We expect them to function physically. They need to navigate the physical environment. And we also expect kids to function socially in terms of their social interaction with peers and adults. And these are the domains in which students are expected to function in the school setting. And not all disabilities impact just the academic domain. There can be other domains that are important. But I think that this point about the fact that the Congress has made clear and wants to make clear that child find could apply even if a student's doing well in the classroom is an important one, because it's led some districts to really be remiss in their child find obligation and wind up losing some court cases, as we'll see. They say child applies to homeless students as long as they are within your boundaries, even if they don't have a fixed residence. You have to undertake some efforts to try to locate potentially disabled students that are homeless within your LEA. You may know about another statute called the McKinney-Vento Act that makes sure that students that are homeless can basically get into any school they want without really meeting the normal requirements of showing a lot of documentation and obviously showing that you live, within the district. That's like, where I live in this park. So the McKinney-Vento Act was intended to make it really, really easy for kids that are homeless that don't have a fixed residence to go to school. So that's the reason that's there. Obviously, homeless students are needy in more ways than just education, but homeless population is no more immune to disabilities than any other kind of population. And probably the literature will bear out that if you're homeless, it's perhaps more likely that you have some forms of disability. It applies to kids that are wards of the state, meaning that are in foster homes, for example, within your area. And importantly, child find applies to students that are in private schools that are within your boundaries. So let's say that you're an LEA and within your boundaries, you have 2 private schools. Though in those private schools, there might be students, again, that may have disabilities or that are suspected of having disabilities or suspected of needing special ed services. And your child find obligation to offer those students evaluation reaches out to those private school students as well. Okay, when we talk about kind of the activities that you want to undertake to effectuate child find, we'll see how you can hit all of these areas. But you can see that the breadth of the requirement is expansive. I am reminded of the decision in Forest Grove. This is an older decision issued by the Supreme Court, I don't know, maybe 10 years ago or so, when one of my favorite Supreme Court justices, Justice White, was on the Supreme Court, and he issued the majority opinion. He wrote the opinion. I love Justice White because he was a really good judge, and he stayed in the Supreme Court, I think, till he was 90 years of age, and he was sharp as deck, and at the age of 90, I believe, wrote this opinion. And in this opinion, he said a child fine violation in special education is the worst violation possible, because he said, if you have other kinds of FAPE violations, well, the child got a denial of FAPE, but they at least got some not so good educational program in special ed. Whereas a child that hasn't been found gets 0 IEP, gets 0 specialized services. They get nothing at all that's specialized in any way. So his point was it's the worst violation possible because you don't even get a cruddy IEP. You get no IEP whatsoever. I really took that to heart. I thought that was quite astute. Okay. Notice that your child find obligation is triggered by a student's residency. In the case of homeless students, their presence within the district. Okay, not enrollment status. Okay, so basically, can you tell a private school student that's not enrolled within your district, we don't have to offer you an evaluation because you're not enrolled within the district? No, you can't say that because they reside. See, your duties under IDA are triggered by a student's residency within the district, not necessarily their enrollment or registration status with you. As homeschool students, for example, are equally subject to child fine. Your FAPE, the duty to offer FAPE to students isn't limited by enrollment. It applies to all students that reside. You have to at least offer them a FAPE. I mean, they may choose homeschooling or they may choose private school, but you have to make an offer of FAPE to these students. Okay, so key idea there. Your duties under IDA, your duty for child fine, your duty to offer an appropriate education are triggered by the student's residency, or in the case of homeless students, their presence within the district, not necessarily that they've come to you for enrollment. And then I've cited to a couple of decisions by the Department of Education. Well, decisions are actually guidance letters that talk about child fine. And they say if you have a child that on a long-term basis is going to be residing in a nursing home or some sort of care facility within your boundaries, child fine applies to them. Okay. Well, let's say that you've had a child that suffered a brain injury, and that child is placed in some sort of a nursing home that's located within your boundaries. You may owe that child an offer of evaluation. Why? Because we might suspect that they have a traumatic brain injury and that they need special education services. So by publishing and having interaction with these facilities, you can ensure that you're putting the feelers out there where these facilities or parents can come to you and ask for an evaluation. But that's not going to happen unless you take some action to establish some connections and some communication with these types of agencies. A letter from 2016. Boy, this was prescient. Actually, before the pandemic hit, there was already an increased prevalence of virtual programs, educational programs, and an increased participation of special education students in virtual programs. And I think that because of the COVID pandemic and the fact that basically most school districts in the United States had to turn to a virtual program, at least for some period of time, is likely to make that model even expand. And the Department of Education says students that you're serving remotely or virtually are equally subject to the child fine obligation, meaning you have the same duties to identify and figure out, hey, do we suspect the student might have a disability? Do we suspect they need special ed? And you have that same obligation to ask those questions with respect to students you serve virtually. The Department of Education does recognize it can be more challenging to effectuate child fine when you don't have the child present, but it's not impossible, because when you have a child in a virtual program, you can ascertain about their academic performance. In Zoom-based type of classroom settings, you can obviously witness the child's behaviors, so that you can still get some suspicions that the child might be disabled, that at least triggers some communication with the parents, and then there can be consensus that the child may need to be referred. So there's no exemption from the child find provision or requirement for students that are served virtually. By the way, I kind of skipped over this question. You might have asked yourself, well, why does the law want us to offer evaluations to kids that are in private schools if the parents aren't at this point really even interested in coming to the public school setting? And the reason that the law affords the parents the right to have these evaluations, okay, is to provide them with the best information with which they can make their decisions on where to place the child. Like, for example, if because of communication between the private school and the school district, and then we determine that there's a student that may have problems together with the parent, and we offer the parent a special education evaluation, the parent consents, we evaluate the student and the student is eligible, and we offer the student an IEP with special ed services. That offer of services, it can afford the parent the information that they need to basically make a decision on the following question, which is, will I remain in the private school setting that maybe doesn't offer special ed services, or should I go back to the public school that is going to offer me this IEP with these specialized services? That's why the child find applies to private school students. It's so parents can make a choice. If the parent wants to remain in the private school, that's fine. Then they're not going to agree to accept the IEP, and they're not going to enroll in the school district. They're going to remain in the private school setting, and that's their choice if they want to. But the law wants to afford the parents that data, that information with which to make an informed decision. Okay, what is child find? It's not a thing, but rather a set of things. I liken it to a coordinated set of activities. And some of these activities are going to be notices that you send out. They could be postings on your website. They could be postings in your office, in your facilities, in your campuses, and in your central office. Notices that tell parents, hey, parent, if you think your child might be disabled, contact us. You know, you're inviting parents, you're putting the feelers out and telling them, if you think your child has disabilities and might need assistance, contact us, and we can kind of talk about it. You might put the similar type of information on your district websites. You're likely to include that information in your published student and parent handbooks. You know, you want to, every opportunity you have when you're in communication with parents, you want to throw in there the fact that, hey, by the way, if you think you know a child with disabilities or have a child with disabilities, we'd like to contact you. We'd like you to contact us about that. It may be that you publish pamphlets. I've seen districts that create child find pamphlets that basically explain to parents the obligation to find students and how they can get the ball rolling with that. And it maybe even go even a little further into what might be available if the student in fact qualifies for special education or 504. And also child find will involve outreach efforts, you know, where you run by the homeless shelter and drop by some pamphlets, or you have a meeting with the director of the homeless shelter about the fact that you're interested in finding any students that may have disabilities, and would he pass on that information to clients? Yes, is there a question?
Yes, but it's from me.
Sure.
So what kind of guidance would you give in like an LEA trying to see if their coordinated set of activities is adequate? Maybe they put out, you know, a newspaper ad in the summer or something, and they have a pamphlet, or like, how do you know when it's robust enough?
Well, you know, one way is to look at your rate of eligibility. The proof is in the pudding, right? What is your percentage rate of special ed eligibility in your district? How does it compare to districts in your region? How does it compare to your state averages? Okay. that's kind of a starting point, because I think if your eligibility rate, I don't know what your eligibility rate in your state is. Do you know? The average eligibility rate across the United States is about 13%. Let's say that that's where Wyoming is, that the average eligibility rate, meaning the percentage of special ed students overall in the states, is 13%, which is about the national average.
Yep,
okay?
we're at 14, so we're very close.
You're at 14. So by the way, the average might be there because the data is always a little old. I think this is 3-year-old data that I'm talking about, and it was 13.2% just 3 years ago. And so just a little bit of a climb could put you in the 14. So you're right smack likely on average. Well, if you're in a school district and your rate of eligibility is 10%, then I think that you're sort of under the state average, and fairly significantly so, right? So I think that just kind of studying where your rate is versus the state average can give you some information as to whether the child find radar, as I liken it, which I'll talk about a little later, is really working. If you're at about the average, then I would say that it looks like the proof is in the pudding. Your child find at least is working enough that you're identifying students at the average rate. But if you're below it, it may be that some aspects of the child find need some work. Also, I would examine this. Are most of the students that you're identified because the parents are referring them? I'd always like districts to keep that data. Where are the referrals coming from? Are there staff referrals or parent referrals? If most of your referrals are coming from parents, maybe you don't have a robust enough system to be finding the kids out there. That's kind of overall indicators as to whether you have enough on outreach. Another feature that I'd say is, do you have homeless shelters in your area? I know you have pediatricians, okay? So you should have some outreach to pediatricians, provide them the child find pamphlets and the notices, etc. Do you have Head Start agencies in your jurisdiction? You might want to provide pamphlets and information to those. And you're going to want to establish contact with the private schools in your area. So that depends on what kind of agencies and programs are within your area that may serve young populations.
Yeah, and also as a reminder, for homeschool associations and things like that.
I'm forgetting that.
That is private school in Wyoming. So homeschoolers would be very important as well.
Absolutely. And ways to find them are there may be a Facebook organization that's kind of located around a Facebook, or it may be a true organization that helps with even curriculum and materials. And if so, and you have homeschool students, then you're going to want to engage in some outreach efforts to that population. To the degree that homeschool students, you could even do a mailing to each homeschool student that lives in your LEA, to at least let parents know, hey, even though you're homeschooling your child, if there's a suspicion of disability and a need for special education services, you can come to us and reach out to us, and we can offer you an evaluation. So how many feelers you put out there has to do with what agencies are out there, how many homeschool kids you've got out there, how many homeless shelters, how many foster kids you have out there. And, the more the better. I think overshooting in terms of your child find efforts is always going to be better than kind of thinking, well, have we done enough? And definitely, I think if you're below the state average, then probably you need to beef that up. You need to make it a little bit more robust.
That's a great point. Thank you.
Sure thing. If you notice, what we're talking about is a proactive affirmative duty on school districts. Meaning what? Meaning you can't discharge your child find obligation by simply waiting for parents to refer students to you. You have to take action. With kids that are in your schools, that may be ensuring that teachers know how to take action to potentially get a referral started by contacting the special ed department, and providing information again and doing these outreach efforts with respect to parents and other agencies. I've been asked in the past whether child find literally requires knocking on doors, and I think so. I think literally it may require, knocking on doors if you have a homeschool parent that, for example, has dropped by the office, doesn't have a phone, doesn't have email. Yeah, it may take, knocking on their door and having a discussion with them about what child find is, and might they be interested in a referral, and what is it that leads them to suspect that their child has a disability. So meaning it's an obligation of the school district to install a child find system and monitor that it continues to be effective. Later, you'll see that I liken it to maintaining a radar that's always out there, bleep, 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 always looking. And it's always ongoing, it's always operational. And you just have to make sure that it's in good working order. I did want to comment on kind of the way that you guys do a lot of pre-K services, because I know that in your state, you have a lot of school districts and schools and elementaries that do not have pre-K. And remember, your child find obligation starts at age 3, because that's the starting age for FAPE. So schools that don't have pre-K, so obviously you don't have eyes on the 4-year-olds, you have to make special efforts to engage in child find for the young kids. And here's where it's really important that you outreach to pediatricians, healthcare agencies, daycares. Get those child find pamphlets to daycares, to places where parents and staff see. A staff at a daycare may have a pamphlet, engage in a discussion with a parent. Oh, mom, I kind of see some ADHD tendencies. Hey, look, here's a child find pamphlet from the local district. You want to talk to them about it? Well, but my child's only 4 years of age. It doesn't matter. Your child could still qualify. Homeschool organizations, here we go. Postings on social media. A lot of districts nowadays have social media sites. I don't know what kind of social media program you may have, but you might want to throw in there the child find notices. The old days, kind of my generation, when I started in this business, it was a lot of newspaper ads, although that can still work. It depends on how well your newspaper circulates. I know that your regional CDCs perform the actual screenings and evaluations for the young kids. They're the schools that don't have pre-Ks, but the districts have to engage in their own efforts to help find the students that may need a referral. So in other words, simply because the CDCs have the evaluation obligation and the obligation to serve these pre-K students does not absolve the school district of its child find obligation. It's the legal responsibility to ensure that a 3-year-old or a 4-year-old is identified at the right time, is on the individual school districts, okay? You guys are in a low litigation state, but in a higher litigation state, you would have already had the following lesson, which is if there's a child find claim on a 3 or 4-year-old in an IDEA due process hearing, the claim would be against the school district. I don't think the CDC, okay? Why? Because these due process claims only can happen against the local educational agencies. And you're a low litigation state, so that kind of hasn't been ferreted out and figured out. But I think that's the way it would work out. So since it's the obligation of the LEAs, don't think that simply because the CDCs are given certain funds, or maybe some of your funds, that they have all of the obligations for these young kids. You have to assist with child find. At the very least, and coordinating with CDC and figuring out, CDC, what are your child find efforts? And make sure that either jointly or by proxy, the CDC is actuating and enforcing your child find obligation and implementing it appropriately. Don't just go to sleep on those young kids and the child find efforts. You want to make sure, if you're a special ed director in a school district that doesn't have pre-Ks, when you lie down at night, you want to lie down nice and comfortable, that you're sure that child find is covered for that age group with the outreach and the activities that you're undertaking. You could do a little data analysis on that. For example, I bet you that your friendly Department of Education folks would probably share with you data that breaks down the eligibility rates for IDEA by age group. And if I was a special ed director, I'd want to know, well, what's the rate of eligibility for my 3 and 4 year olds? Oh, well, it's kind of 5%. Well, what's the state average? I'd want to know what the state average is. Is the state average higher than that? Because that may mean I need extra child find work. That the big picture data can give you information on systemically whether you need to be more assertive with your child find obligations. Okay. Any questions before I move on to another issue?
I don't see any in the Q&A at this time.
Don't be shy.
Okay.
I'll turn to an issue that in the modern era has raised a significant complexity, and that is that in the modern era of education, and I guess from, I don't know, maybe the early 2000s on, so we're almost 20 years into this, we've had an expansion of the types of interventions that are available in regular education. When I started in this business, there were 2 speeds to the system, the regular and the special, and that's it. If, who are the kids that were referred to? Kids that aren't working out in the regular, and then we just move them into special ed. But nowadays, within regular education, districts have grown to understand that and to grow a lot of variegated and various types of programs of interventions that are available within regular education, so that actually the regular ed gear has lots of different speeds. And the main modern child find challenge that is presented by these intervention programs is you want to make sure that you use RTI, response to intervention thinking, and regular ed intervention programs in ways that don't work against child find, in ways that don't compromise your child find duties under IDEA. Meaning that you want to ensure that as you're implementing these regular ed interventions for students that are struggling academically, that you don't do it in a way that results in delays or denials of IDEA evaluations, because that you don't want to do. Okay, you want a proper balancing of approach with RTI. By the way, what's RTI? Well, in a nutshell, it's the idea that if you have a struggling student, student that's struggling with a regular curriculum, I think primarily academically, that you act in providing high quality research-based interventions to these students first, because you don't know why they're struggling, certainly not initially. And the idea is then you examine how the students are responding to the interventions. Because the idea from the experts on learning disabilities is if you have a child that's struggling with a regular curriculum and you hit them with some quality interventions and they start improving, they start responding, then likely they don't have a learning disability. You don't have to worry too much about them. But the converse is true, though. If you hit a child with high quality research-based interventions and still things aren't working out, that may mean that the student may have a learning disability and may need to be referred to special ed. So the purpose of RTI is twofold. Improve the performance of struggling students that are non-disabled. There can be non-disabled struggling students. Every school district has them. So what we're hoping with RTI is improving the performance of these struggling non-disabled students, while at the same time, we're better identifying students that may truly have specific learning disabilities and need special education. That's how RTI is supposed to work, all right? And it's now incorporated in the analysis for determining if a child has a learning disability. Not to get too far afield into this, but here's the federal regulation that tells us how we identify and evaluate and make a determination that a child has a specific learning disability. And it's sequential. First, you make a finding that the child's not achieving, in the classroom. Then the second and the most important step, I think, is kind of an optional step. You do an RTI analysis, meaning you've given the child high quality research-based interventions and you determine that they're not responding, you can do that, or you do assessments, kind of old school. And hopefully you do these assessments in a more modern way, and you're not just looking at simple differences between IQ and achievement, but you're more looking at patterns of strengths and weaknesses that are cast by the profile of sophisticated cognitive assessments and achievement tests, hopefully broken down in a way that analyzes cognitive ability a little bit better than just, you know, reaching a one number score, so that you can see how the student's cognitive processing works, and you can compare the patterns in areas of cognitive processing against the various patterns that are cast by achievement. And I'm talking kind of like more in terms of analysis, likened to cross-battery assessment, which is a research-based way of looking for strengths and weaknesses. And you can see the research of folks like Don Flanagan and Salomon Ortiz and others on cross-battery assessment. But the third step is you make sure that you're not qualifying the student as LD because of some other disability or non-disability factors. And lastly, you want to make sure that you're not qualifying a child as LD just because they had bad regular ed in the past. Okay, so notice that the reason that I include this is that RTI analysis can be a part of the LD evaluations. And I think that's embedded in your LD model, because I think I've seen your LD model, and your LD model is either you're going to do RTI, or I think you're going to do discrepancy, which is still kind of old school, but that's the reason why where RTI sort of fits into the SLD analysis. So you can look at that, but it's discretionary. You don't have to use RTI as part of an LD evaluation, because you can use assessments instead. But the new questions that are raised by districts that use RTI, which if you don't call it RTI, it's that you have some other forms of intervention. I don't care, but the idea is you have interventions within regular ed, and if you're using them with kids that are struggling, it raises questions vis-a-vis the child find requirement. And the questions that are important is, at what point in the intervention process should you start suspecting that the child is LD and maybe decide to refer them to special ed? And in my opinion, I don't have a tremendous amount of patience in terms of watching how a child responds to interventions and are not really improving fairly quickly before I'm going to say, I'd rather err on the side of let's refer. We can continue with the interventions during the referral, but you know, I get worried fast. Okay. How long should interventions be tried? I'm not a fan of, well, we got to exhaust all the interventions and the student has to show us a certain degree of failure in all of the tiers of interventions before they can earn a special ed evaluation. Like you got to go through tier 1 and tier 2 and tier 3, these rings of fire, and the student has to jump through these rings of fire before they earn an evaluation. I don't like that. To me, I think in the RTI process, if we don't see some response fairly quickly, I'm as, you know, because I'm more child find oriented, because that's the legal requirement. I want to make sure we're in compliance with that. I'm going to kind of think, let's refer. And again, the fact that you're deciding to refer a child does not mean RTI goes out the window. You can continue the interventions through the referral process, which is going to take at least the referral and evaluation process, which is going to take at least a couple of months, right? What if the child is moving through RTI with some improvements, but also deficits? Well, that worries me, because I've heard this conversation with parents, and the school's like, oh, he's doing better with RTI. And the mom's like, well, I just got his grades and he's kind of failing. You know, is the parent going to be impressed with these dibble points gains in RTI program when the child's still failing in the classroom? So part of whether a child is responding to interventions is how are they responding in the intervention program, but also how are they responding in the classroom? Because if that improvement in intervention programs isn't trickling down to classroom, I'm not going to be that impressed. And certainly the parent's not going to be that impressed. And within this system is, how do you handle parent referrals? You know, if in the midst of an RTI process, you get a parent that refers the child to you, what do? Do you stop the interventions and just refer the child? You know, I think that in those situations, you tell the parent you have the right to refer the child, and likely, even if we're not 100% in agreement, that the answer is going to be, okay, let's go ahead and initiate an evaluation, but hopefully reach an agreement that whatever interventions are being provided can continue during the period of referral and evaluation, which is going to take a period of some weeks. What role do campus assistance teams play? Well, usually they play a role in in figuring out what interventions are we going to provide, monitoring the response on those interventions and communicating with the parents. And these campus assistance teams, in my opinion, need to be trained on child find. Because if they allow a student to languish too long in an RTI program, as you'll see in some cases, you're playing with potential district child fine liability, because if it's not just about identifying a student and offering a referral, you have to do it at the right time. You can't wait. If you delay a child fine delayed is child fine violated, okay? So there is such a claim as, yeah, you evaluated him and he qualified, but you did it too late, so you owe the child some favor. The ultimate question is, how do we make effective use of hopefully quality regular ed interventions while also respecting the child find obligation? That's really the balancing that you've got to draw. You want to make use of your regular ed interventions, but not to the point where child find suffers. Yes, Ms. Shipley.
Yes, I have one quick question and then a different question. Campus assistance teams, is that like a BIT team, like a building intervention team, or?
Yes.
That? Okay.
Yes.
I hadn't heard that term before, so I just wanted to be sure.
It's fairly common, but these types of, I've also heard child study team.
Mm-hmm. Okay.
What is yours, BIT?
Building intervention team, BIT team.
Building intervention team.
Is most common, yeah.
These teams have lots of different names. This is nothing statutory.
Okay.
This isn't anything out of law. Depending on state practices or even local practices, these teams will have different names. Okay. All of it is the same thing. It's teams of staff that are studying students, usually one by one or in groups, usually students that are struggling, and these teams are sort of a collective of brains that are trying to make the best decision as to what should happen with individual students.
Okay, perfect. I hadn't heard that term, so I just wanted to clarify. And then I had a question, and then somebody else also has a question. So my question is, we know the exclusionary factors for eligibility, and the one I'm thinking of is lack of exposure to quality instruction.
Yes.
Do those kind of exclusionary factors, is there a link to that in child find or not a link? Are those any kind of considerations when you're talking child find?
No. I want to be real firm on that.
Perfect. Okay.
Addressing the exclusionary factors, and this is actually a separate one. This one is the fourth factor, which has to do with whether you feel that the scores that you're getting are primarily caused by lack of appropriate instruction. I want to be firm that these discussions live in the evaluation stage, not child find. Okay?
Perfect.
If those factors are present, that's something we're accounting for as part of the evaluation and in writing the evaluation report, not in denying child find.
Yep. Okay. I just
know why? It's simple, because a child that's gotten a cruddy education can also have a learning disability. You think that kids that got a cruddy education in elementary are immune from learning disabilities? They're not.
Right.
They can have both.
They may be a 3 or 4 year old who has had no education.
You can have a student that has significant history of educational disadvantage and also has dyslexia or a reading disability. Those students can exist. So it's really important that type of consideration not happen at the child find stage. It's really important that it happen in the context of an evaluation where you're going to get all of this information to help you better make decisions on it. Because you can tell. For example, if you have a student with educational disadvantage, you're going to see achievement scores are going to be globally depressed. All of the areas are going to be weak. And that can actually show you. You've got a student with a fairly good IQ and they're just kind of depressed all the way academically in a flat achievement profile. That's a hallmark of something that globally is depressing the student's functioning. And that could be something like educational disadvantage. Whereas if the profile that the student with educational disadvantages is casting is that the achievement is, there are weak areas, but there's one area that's super, super weak. Well, wait a minute. You know, that could be a child that is LD plus has educational disadvantage. A little while later, you'll see that I have a slide on reasons why I don't think you decline referrals, and that's one.
Perfect. Thank you. We have a couple questions. I'm going to go to Lewis. Hi, Lewis, you're on mute. Lewis, can you unmute yourself, please?
You're still muted, sir. I'm going to ask him to unmute.
Dina, is that something you can help with?
Yeah, I've been doing that, but I can't unmute him. He'll have to unmute himself.
Is there another question we can?
Yeah, there I go. Hey, I got it.
There you go. There you go. So I hear you now.
Yes. Hey, I have a question. They're building an intervention team, and they identify maybe a child that needs special education. Well, do you have an intervention plan before they actually become evaluated, or do you have to evaluate them then put your intervention team in place or plans?
In my opinion, if you've reached the point where a building intervention team suspects that the child might be special ed and in need for services, I think that the referral happens, but with an understanding that referral, evaluation, and ultimate IEP team meeting to review an initial evaluation is a process of months, maybe a couple of months, maybe 3 months. I would want that building intervention team, because I'm assuming the child is struggling and struggling mightily. I'm going to want that building intervention team to put an intervention program together and implement it during the period that the student is getting evaluated, so that this student is not just sinking. Absolutely, this student needs help immediately. And I want to emphasize, because this is a good teachable point, that providing interventions is not mutually exclusive of evaluation. You can have evaluation happening at the same time that you're providing interventions. And too many districts, they think, well, you know, either intervention or evaluation. So if there's going to be evaluation, we just stop helping the student regardless of how he's doing. And I don't think that's necessary, and I don't think that's appropriate, because the child is struggling and the times to get the evaluation done are pretty lengthy. So I think I'd say put your intervention plan and let's have at it, so that at least the student's not bottoming out, because, you know, he's got classes to pass while we do this evaluation.
Thank you. Yes. Thank you.
Okay, Mr. Martin, that's all we have at this time.
All right, I'll move on. So I sketch out the areas of complication that you can have with RTI, and I think what's the timeliness of interventions is one. My partner likes to talk about this quite a lot, Dave Richards, which is sometimes we're late in starting the interventions and then the child doesn't respond, and we want the interventions to persist, but you know, we kind of applied them too late. So that really delays the process. The other thing that's really important is that your teams or individuals be monitoring how the student is progressing interventions, and the harder that data, the better. And what rate of progress do you have in interventions? Because if it's really, really slow, I'm not going to be terribly impressed. If it's not sufficient so that the student can tackle the regular curriculum, it's still going to be discouraging. I know that in some districts and in some states, we kind of follow a tiered model of multi-tiered systems and supports. I'm less wedded to that type of model being implemented in a very rigid fashion, because, you know, I know there's suggested intervention periods and suggested amount of tiers, usually 3 tiers, but I'm not necessarily beholden to that. I don't want school districts to think if we have a 3-tiered model, the child must suffer through every single tier and show us failure at every step before they're entitled to an evaluation. That can really really lengthen the process and lengthen the getting to an evaluation. And then the child winds up eligible, and the parent is entitled to say, why did you put my child through the 3 rings of fire for all this period of time? Don't you owe me some compensatory services? And we might not have good answers to that. Sometimes schools, I think, what they do is the parent is asking about special education, and the schools are overly encouraging about interventions. And I think that's not respectful of the fact that the parent should, the position to parents about evaluation should be, you can ask for a special ed evaluation at any time. And I want to emphasize that. At what time can the parent not ask for a special ed evaluation? Really at no time, as long as the child's within eligible age. There isn't a wrong time to ask for a special ed evaluation. Now, every time that the parent asks for an evaluation, the school district doesn't necessarily have to agree, but generally you're going to want to. You'd rather show a parent with data that the child doesn't qualify than have the risk that you don't identify a student that then continues to have problems. And I also have a little bit of an issue with use of RTI for non-academic deficits. And the reason for that is, although I see I see behavior RTI, I've heard speech RTI, I've heard RTI outside of the academic areas, and I must say that my review of the research is that the validity of the RTI analysis system is most best and grounded in LD and the world of learning disabilities, and outside of that, it's a little iffy. I only wanted to show you this for your own reading. This is a memo that was issued 10 years ago by the Department of Education that just highlighted the problem of overuse or kind of too assertive a use of RTI in a way that it results in denials or delays of timely evaluations for kids that should really be evaluated. And the basic position of the Department of Education is RTI is great, we support it, but you want to make sure that you don't deny an evaluation to a child that the current data suspects really needs evaluation, really is suspected of having a disability and a need for special ed services. And I think that the statement of the letter that's most important is the one in red. They basically said, we think it's a violation of child fine to reject a referral simply because the child hasn't participated in an RTI framework, okay? They're basically saying, if you're rejecting referrals just because the child hasn't done RTI, that's inappropriate because there's no requirement that the child do RTI or do an RTI sentence for a certain period of time before they earn the right to an evaluation. And I asked, does the statement apply to parent referrals or any referrals? Certainly it applies to parent referrals, but I think it applies to referrals from any source. We shouldn't be telling teachers this referral is not valid simply because the child hasn't participated in RTI if the teacher's information itself appears indicative of a suspicion of disability and need for special ed services. And in those situations, what may be warranted is let's do some interventions at the same time that we start the evaluation. And that's the letter from 2011. In 2012, they said, that you're implementing RTI is not a good reason to deny a parent's request for an initial evaluation. They also don't like what happened in the Artichoker case. This is a case out of South Dakota where a parent requested a special ed evaluation, but the school district responded with RTI instead. I don't like that. A parent comes in and says, hey, I'm interested in a special ed evaluation. I suspect that my child has a disability and might need special ed services. And the school says, no, look over here. RTI intervention, so that, we're not going to give you a referral. So, the consolation prize that you get is RTI interventions. And in fact, the federal courts generally look at that type of situation as a denial of a referral. And if you have a parent that requests an evaluation and you decline the evaluation, the IDEA and the courts have indicated you owe the parents 2 things. You owe the parents a prior written notice explaining why you're declining the referral, that 7-piece thing. And you're supposed to give a parent a notice of their procedural safeguards. You know why? Why would you give a parent a notice of procedural safeguards if the child isn't eligible? Because the parent is entitled to know they can contest and object to the denial of the referral, including by filing a due process hearing. They're not going to know that unless they get their procedural safeguards. And by the way, the position of the Department of Education with respect to RTI is the same also with respect to 504. Now, I know this isn't a 504 presentation, but I wanted to add it at least in the materials. The position of the Department of Education is consistent in special ed and 504, that you want to make sure that you don't rigidly apply your RTI in a way that results in denials or delays of special ed, of Section 504 evaluations in this context. And I give you some cases where even kids with ADHD were made to go through RTI. What's an academic RTI program going to do for a child with ADHD? And then the ultimate of insanity, which I just with RTI run amok, is the Forest Hills case out of Ohio, where every child with diabetes was required to do a month-long process of RTI prior to evaluations. Diabetes RTI, that one was a real new one on me. That's just overdoing RTI and disrespecting child find under 504 in this situation, and certainly child find under IDA equally problematic. So this is, the problem areas in RTI or in child find, or in your case, you have these building intervention teams. Just make sure that you're not absolutely insisting on a bunch of interventions prior to referral and viewing interventions as some sort of a prerequisite to referral. You make sure you inform the parent of all the options. These are intervention options, but you can also ask for a special ed evaluation. Never hide that from parents. You want to consider their input. How nervous are they about the child's deficits? How deep are these deficits? And make sure your intervention tries and attempts aren't overly lengthy, and that you're not rigidly just adhering to some sort of a tiered model just because that's that model. Those are the areas where I'd say be careful. Let's get to some cases, okay? This is a fairly recent case out of Arkansas, Whitehall School District. And this one also shows that sometimes school districts can be misled by the fact that a child is passing and decline to evaluate. So you have this 10-year-old, and yes, she's passing her classes, but her parents are worried because her reading seems weak and her academics seem weak. And the teachers, in fact, have requested a referral of special education, but the request is rejected. Instead, the district adds dyslexia intervention services, which are unspecified. The parents, because they're nervous, they get an independent evaluation. That independent evaluation actually says the child has autism spectrum disorder and learning disabilities. Despite the fact that you have teacher referrals, you have some problems with a student, and you have this independent evaluation, the district doesn't refer the child to special ed, but rather gives the parents a Section 504 plan as a consolation. Ultimately, when the parents get an attorney, the district finally evaluates the student, and lo and behold, the student qualifies. So the teachers were right all along. And then the evaluation dragged. They took a long time to complete the autism evaluation. And when the child got an IEP, it wasn't a great one. It didn't include specific special ed services and had one measly goal in the area of reading, which was the big problem. And the hearing officer said, you messed up. The minute you got that independent evaluation, you should have referred the student, because you had ingredients. You had the teacher evaluating the student, you had the parent being concerned, and you had this independent evaluation. And the hearing officer noted child find applies to students that are passing. And here this student was academically behind despite the fact that she was passing. Sometimes informal accommodations or extra effort on the part of the student can mask the fact that there's problems underlying those issues. So the hearing officer also found that the IEP was inappropriate and found that the parents won and ordered 50 hours of compensatory services. The lesson of the case, you have teacher concern plus parent concern plus IEE concern. You better evaluate. I mean, do you need even all that? You shouldn't be lulled into a false sense of security that you don't have to refer a child just because they're kind of passing, even if you show statewide assessment scores are weak and standardized scores in reading are weak. Be careful, be careful. They should have done the dyslexia interventions while the special ed evaluation was pending. And what it would have found is there is a learning disability. Okay. I find that with some evaluators, they say, well, you know, we evaluated the student and they didn't qualify. So that's a total failure of the process. No, it's not. It's not. I think a proper child find envisions that at times you're going to evaluate a student that does not qualify, and that's okay. Not every student that you go through child find because you have a suspicion eventually qualifies. That's absolutely okay. The standard for triggering child find is suspicion of disability, suspicion of need for special ed services, not absolute certainty that a student is going to qualify. The Avaris case out of New York is just sort of RTI abuse here. So you have this first grader and they make him go through 7 months of RTI despite the fact that he has struggled through tiers 1 and 2 in kindergarten. So he struggles in tier 1 and 2 in kindergarten, and what do we say? More. He's got to do it now in the first grade. So the district decided to do tier 3 in first grade for 9 months. That's a full school year. So a total 16 months in RTI without referral, and the student is struggling because they're saying, well, he's making some progress on RTI. It's not showing up in the classroom. That's a problem. That's a problem. You can't gauge how a child is responding to intervention purely by seeing how they respond to the intervention program. You have to see, is it actually resulting in the child improving in the classroom? Are the grades improving in the classroom? Is mastery of the curriculum improving in the classroom? Ultimately, the school agreed to an IDA evaluation after 16 months of RTI, and the student, lo and behold, qualifies. Don't you think he would have qualified a year earlier? Of course he would. So the court found a child find violation. And again, the court said, we know the child is advancing from grade to grade, but you still might have a child find obligation. Okay. In fact, the court said after about 8 weeks of RTI, meaning one period of RTI progress monitoring, you probably should have evaluated because there wasn't a robust response. I agree. I think that in RTI, it's not a matter of months. I think it's a matter of weeks. And I need to see a response fairly quickly. Or otherwise, my child find spidey sense, my child find just gets nervous. Okay. Many times I think schools are reluctant to evaluate the younger kids, although the child find requirement applies equally at an earlier age. And remember, particularly with reading issues, because the literature says the earlier you catch reading issues, the more effective the interventions will be. You catch a reading disability in middle school, and it's going to be real tough to get the child to grade level. There's kind of a window there beyond which it can be difficult to remediate the learning disability. Remember, just because that a student is passing doesn't mean they're doing great with maybe RTI interventions and don't need referral. Those underlying achievement scores could be stagnant, okay, and not improving, and that's not a good look. This is, to me, my protocol for kind of balancing RTI and child find, and it involves providing parents with information on all the intervention policies and process up front. So if you guys use these building intervention teams, you tell the parent, hey, look, we're going to refer the child to this building intervention team, and this is what they do. And hopefully you do meet with the parents, maybe not as part of the building intervention team, but you meet with the parents to discuss the options. You want to make clear to the parents that they can request a special ed evaluation at any time. Try to reach consensus on what you're going to do, whether it's intervention or referral or both. Share that progress monitoring data with the parents as to how the child is doing in the intervention programs, and then follow up. Is the child progressing or not? Have review meetings and document the steps you're taking in the consensus decision making. And this process should work rather rapidly. Okay, it should not be something. The worst situations are where the child languishes and lingers in RTI for a really long time. And notice that the goal I'm trying to achieve in this type of a protocol is a proper balance of RTI implementation, respect for parental input, and the IDEA child find obligation. It's kind of a balancing. You want to implement RTI, and you have child find over here. And what wins? Child find wins, because child find is the legal obligation you must make sure you're complying with. When in doubt, I think the safest course of action is to evaluate. Remember, the standard for evaluation is not, I'm absolutely sure the student is going to qualify. That is not the standard, okay? If If a diagnostician or evaluator says, well, I don't think the child is going to qualify, and does, you know, that's not the question. The question is whether there are reasonable grounds to suspect they might. Okay, because sometimes kids can surprise us with respect to evaluations. You don't want to guess what an evaluation is going to say. That's something you don't eyeball. Parent requests for evaluation. I'm not your attorneys, but I'll tell you what over the years has been my message to my clients in 30 years of practice. And that's, if a parent refers a child to special ed, it's probably safest to go ahead and do the evaluation, even if we don't think there's quite suspicion. I think it's better to show a parent with data that the child doesn't qualify than to try to convince the parent that they don't need the evaluation and then have to do the prior written notice and have to give them their procedural safeguards. I indicated earlier that I had a slide on common but not good reasons to decline a referral, okay? I hope I've already nailed this one. It's not appropriate to decline a referral because the child hasn't participated in all RTI tiers or hasn't done enough RTI if it's been weeks of it. It's not appropriate to decline a referral because of the possible presence of exclusionary factors. And that was a question that was brought out earlier. And, you know, I answered it firmly, no. Sometimes you have students that have been absent a lot. There's evidence of educational disadvantage, a lot of moves, language difference. All of these are things that need to be addressed in the evaluation, not at the referral stage. The fact that a child may have language differences does not render them immune from disability. It just means you're going to have to be more careful in the evaluation process. So we don't decline child find because of the possible presence of exclusionary factors. Those exclusionary factors are exactly that, factors in the evaluation. That's where you look at that in the context of the other scores, as I talked about earlier. Same thing with lack of access to appropriate instruction. Let's say a child hasn't been to school until the second grade. That doesn't mean they're immune from a learning disability. They could still have one. They could still have some other disability. That can happen as well. Both things can be present. You will assess a lack of access to appropriate instruction in the context of other evaluation data. Again, if achievement levels for the student are globally depressed, reading, writing, math, everything is depressed because the child hasn't been to school and it's equally depressed, then I think that you have your data is actually supporting your hunch that what's at play here is a lack of appropriate instruction, so a student doesn't qualify. But it can surprise you. Within that, you could still find a student that is low, but there's some areas that are even lower and could potentially qualify the student as LD. And I don't like to hear the child's too young, give them a chance, you know, because they're in pre-K or K, or they're too old. What are we going to place them in special ed for at 18 and so forth? For whatever they can get. That's the answer, you know. And again, for a student is passing their classes, even though there may be indications of below grade level performance. And I'll give you some examples in some of the cases. I'm going to skip because I want to talk about some cases and the lessons therein. This is a recent one out of Texas that I think has some hard lessons for school districts. It's the Klein case. Okay, so you have a sixth grader, and this sixth grader has had long-term reading difficulties because he got RTI in first, second, third grade. Okay, for God's sakes, he's getting RTI a lot. The main issue appeared to be problems in reading comprehension. The student is placed in section 504. He's actually been tested for dyslexia but doesn't qualify. So he's placed in 504 for reading difficulty. What in the world does that mean? And the 504 plan just includes some accommodations, no real services for reading. So you can guarantee it's not going to work. If I was the 504, I'd say, you've had this child in RTI for reading for a whole long time, kind of an RTI program, and now you're giving them to us under 504. What are we going to do? What are accommodations going to do for this kid? That would have been my point. I mean, why do we think that an accommodation plan is going to work when the RTI interventions haven't? In the fourth grade, he fails to meet benchmark standards on the statewide assessment. And notice where he's at in reading. He's at the bottom 2 percentile in reading, even though he's passing his classes. This kid's really dedicated in passing his classes, continues to struggle. We're now in the 5th grade, by the way, but he's not referred to special ed until the middle of the 5th grade and until the parents are absolutely knocking down the door. And lo and behold, that evaluation determines he's learning disabled in reading comprehension. Who would have thunk? Who would have thunk? I think we could have probably figured that out 2 or 3 years before. And then notice what he gets in his IEP, which is not great. Less than 4 hours of co-teach in a co-teach special ed, regular ed classroom, and 30 minutes a week dyslexia services, apparently because an advocate was screaming for dyslexia services when he's not dyslexic, okay? Unsurprisingly, he doesn't improve. The parents file for due process. The hearing officer says he's not dyslexic, you just failed to address his reading comprehension issues. And the matter goes to district court, and the federal court says, yes, you have referred this child woefully late and you violated child fine. Way, way late, maybe 3 years late. And the court also agreed the IEP services are insufficient because this co-teach in the regular classroom, there's no specialized program to address the reading comprehension learning disability. How is the child going to improve? Painful lesson for the school district because the court awards a bunch of compensatory services and 71 grand in attorney's fees. And the court said there would have been more comp services if the parents had actually filed earlier. But in Texas, the due process hearings can only go back a year. But very difficult. I mean, and the lessons that I want to draw from you in this case, 3 years in RTI, craziness, insanity. A year in RTI, insanity. Months and months in RTI, come on. We can't figure out if the child's going to respond or not within that period of time. 3 years in RTI and then only a referral to 504? No, inadequate. A big surprise to me of this case is why the district would expend the likely hundreds of thousands of dollars it took to litigate this all the way to federal district court. You know, why didn't the 504 committee refer the child to special ed in the 3rd grade, knowing he'd received already 3 years of RTI and he was only going to get 504 accommodations? Or why wasn't the student referred in the 4th grade when he got terrible scores on a statewide assessment at the 2nd percentile? I mean, I think the district was misled again by the fact that the student's making passing grades, but inescapably the reading is just getting worse and worse. And then they compounded the problem by putting an IEP into place that really didn't have any specialized reading services for a student that has a very specific learning disability and reading comprehension. Okay, I'm not sure that the school knew what to do with this student. Okay, but the main lesson I want to draw for you guys is this student should have been really referred to special ed way before. Okay. The Spring Branch case out of the 5th Circuit is a case of another type of child fine. And in here, there's a child who's been for years in private school. And after a stint in private school, and they're in the 5th grade, they enroll in the public school. And immediately, the student begins struggling behaviorally, despite the testing that shows high IQ. Upon enrollment, the parents had submitted a letter saying the child has ADHD and may need accommodations. I think he needs a little more. Check this out. The first day he attends public school, the teachers find he has drawn images of murder, anti-Semitic content, and obscenities. This is what we do on the first day of school. The next day, the student shoots the finger at staff, is defiant, cusses administrators, and throws objects at the assistant principal. There's no honeymoon here. This student is going to throwing stuff at administrators on the 2nd day of school. Parents now come clean and say, oh, by the way, you know, the child has been diagnosed also with oppositional defiant disorder, mood disorder, anxiety, and depression. Instead of saying, wow, let's start a referral, the school contacts staff from the prior school to consult on the student, but the behavior problems are persisting, and the school doesn't offer a special ed referral. they just offered a 504 evaluation, despite the fact that the parent is providing yet another private evaluation showing psychiatric issues. The 504 team does its best. They put together a behavior intervention plan, doesn't work. The student's grades are dropping. After a certain period of time, the student assaults a teacher and it results in police charges. They finally decide to refer the child to special ed, and he's placed in an adaptive behavior program. Things don't work well after that. He's restrained 8 times. Police are called 4 times. Officers threaten to take him to jail, and the parents pull him out of school because he's been traumatized. And then when they return him to school the day after, the principal and the parents say, hey, can we just have him come to school 90 minutes? So they kind of just reach an informal agreement that he's only going to go to school 90 minutes. Later, that was changed to 3 hours per day. With no IEP team meeting, this placement is changed. So the parents ultimately, they sue. And again, the hearing officer says this is another woeful child find failure. And when you put him in special ed, there's a failure to provide a FAPE. You shortened day without an IEP team meeting, all these restraints, all these calls to the police. You are not providing a FAPE to a child under these circumstances. So the point that I want to raise in this case is the court says, you know, at times you need to skip section 504 altogether. It's not an intermittent step in all cases. If you don't suspect the child needs special ed services, 504 can be a good answer for a child with disabilities. But here, there's not a suspicion of special ed. Come on, second day of school, the child is throwing things at an assistant principal. So the court says, unsurprisingly, based on the severity of behavior, it was not reasonable to try intermediate measures. You needed to go to referral right away. It might be okay in other circumstances, but not here. But at least the court found that the restraints were appropriate on an individual basis, and that use of police, you know, was there because there was a risk of substantial injury. But it was not a good case for the district. And I comment, by the way, on another point, not on child find. If you're shortening a child's school day due to behavior, you're more than likely losing the case, okay? I mean, I think responding to a child's inappropriate or persistent misbehavior in special ed by shortening his program is basically surrender. It's the white flag of education. We can't handle him the full day, so can we just have him a half day? That's not a decision based on the child's needs. That's a decision based on the fact that you just can't handle the situation. So be very careful. I'm gonna skip, in the interest of time, because I wanted to make an important point, and that is that I don't want to sugarcoat the fact that when you're engaging in child find, you have to navigate a bifurcated system. What do I mean by that? Section 504 and special ed child find are happening at the same time. You have a duty to find 504 students on an ongoing basis, and you have a duty to find special ed students, okay? And you have to figure out, when does child find go through the left fork of the road to 504, and when does child find go through the special ed angle? And I'll tell you that the answer has to be based on the child's needs. What does the child need? It's not so much disability. If you tell me, where does a child with ADHD go? I don't know. Sometimes special ed, sometimes 504. It depends on what they need. If a child appears to need special ed, you need to go the child find of special ed route. But if you don't think the child needs special ed, going 504 is okay. But the points I want to make are the following. If you're implementing a 504 plan that you've tried to revise and the student is still struggling, that's a potential child find candidate for special ed. So students that are not doing well despite a 504 plan are active child find candidates for special ed. Special ed programs need to have eyes on those students. So there has to be communication between 504 and special education regarding these students. The 504 coordinator at the district should know quite well the special ed director, and they should meet for coffee fairly frequently. You know, grab one in Starbucks and let's talk about a couple of kids. I told you earlier, I think of child find as a radar that's always going, and you should always be asking yourself, how good is our radar? How well is it operating? Are we finding 504 kids? Are we finding special ed kids? You know, in 504, is it getting the kids with health plans, with reading disabilities, with indications of ADHD? You know, that's a kind of concern that I will raise. I'm going to skip the Kravitz case. And I wanted to talk about this District of Columbia case because I think this poses a sad, but unfortunately existing and more common than we want situation of child fine in the United States. And that's students that either have suicidal ideations or make suicidal attempts. And here you have a student with autism. Apparently he was dismissed from special ed after a reevaluation. And then he's provided a 504 plan, but he gets bullied at school and the student attempted to hang himself as a result of the bullying. And this is a pattern that plays itself out across the United States, sometimes to very tragic ends. After the suicide attempt, the parent, I think very rationally said, I think we need a new special ed evaluation, but the school district said no, because he's doing well academically. As if that's the problem. He wasn't even doing that well. He's failing a class. The hearing officer noted, but everybody knew that he was struggling with peer interactions, struggling with inappropriate responses to peers, with changes in routines. The hearing officer actually says whether the child's making academic progress with 504 has no bearing on the student's special ed eligibility. I don't think that's exactly true, but I know the point he's trying to make. This student's problems might not be primarily academic. This student's problems, and if there is a need for special ed, it's going to flow due to the behavioral or social domain. And students can't qualify on that basis. I mean, high functioning students with autism can still qualify for special ed, even though they're academically proficient, because they may have significant problems in socialization, they may have significant problems in behavior. So against the backdrop of a suicide attempt, what do I think of the decision to deny an evaluation? I think it's craziness. Why would you deny an evaluation in that circumstance? The parent's asking for it and the child just attempted suicide? I'd say yes, absolutely. Why not? Why wouldn't we? Okay. And the Yankton case, which is the last case I want to cover, is just an example of how special education can function in an entirely physical domain. You know, in special ed, we have eligibility categories for students with orthopedic impairment. Not everything is about academics. I know that we kind of think that way because so many students are in special education as LD due to academic difficulties, about half of students. But there definitely are students with that may be academically brilliant, but they're blind, or may be academically brilliant, but they're deaf, or have cerebral palsy, like in this situation. You have a high schooler here with CP, and she gets adaptive PE, a variety of other types of physical accommodations and related services. But apparently when she completed her PE requirement, the school said, well, you know, adaptive PE was the only special ed you got, so we're going to dismiss you from special ed and provide you services under 504. And the parents contested the dismissal. And the court said, but this accommodation, assistance between classes, getting off and on the bus, helping her with the stairs, helping her at lunch, this constitutes special ed services. That's actually wrong. It's not. It's not. A paraprofessional can provide assistance getting off and on a bus and with stairs and carrying a lunch tray. That doesn't translate to special ed. That's not specialized instruction. My question is, these services, I think, could have been provided under a 504 plan. Do any of these services really require a special ed teacher, special ed instructional assistance? But I know what the court is getting at, and this is kind of an older decision. I think what the court is getting at is the point that I want to raise, which is at times you can have a student with physical disabilities that does need something like adaptive PE. And that student might be academically brilliant, the best student. I mean, if we think about it, think of the brilliant astrophysicist, Stephen Hawking, a brilliant astrophysicist. And I think about him in a mental experiment. What if he was in high school? And in high school, let's say that he had Lou Gehrig's, right? And he's essentially completely physically infirm and dependent on others. he would need speech therapy services, assistive technology, adaptive PE. He'd need significant special ed if he was in school. But if you notice, he'd be the most brilliant person in the school, in the district, in the state, but nevertheless, probably in need of special education services. So we need to divorce ourselves from this concept that students that are academically functional can never qualify for special education. That's a key child find misconception that I want to evaporate today. And with that, I think we're close to the end of the presentation. And I do have a couple of minutes for questions. Do you have any, Ms. Shipley?
I don't have any questions, but I sure want to thank you, because my knowledge of child find is getting refined as we go through these court cases, and we can always learn and grow on this subject, and I really do appreciate it. I know it's sometimes a challenge in Wyoming,